Lastly, what I want to talk about is employees' rights at work. They have lots of them. They have 27 of them and counting. Now, rights at work are basically, you have statutory rights and you have contractual rights for an employee. Now, the contractual rights cannot take away the rights that an employee has by law. And to give you an example, if your contracts of employment say that your employees are entitled to 10 days holiday per year, well, the statutory right to holidays in the UK is that they're entitled to a minimum of 28 days, full-time equivalent employee per year. Therefore, in that instance, if you're giving out a contract that an employee signs and agrees to, they say, okay, that's the deal on the table, I'll take it. That part of the contract would not be enforceable. And what that means is that the statutory right would apply. They are entitled to 28 days and they could take a claim against you if you're only prepared to give them 10 days holiday in that year. Equally, if your holiday entitlement for that individual is 35 days, the statutory entitlement is only 28, therefore the contractual rights to that individual would apply. They have a contract given by you that says they have 35 days holiday per year, therefore you must give them 35 days holiday per year, otherwise you find yourself in breach. What you can do, however, is the additional days over the 28, so those additional 7 days, you can dictate when they can take those holidays. You still have an element of control over the statutory holiday, right enough, but for those particular days, you can dictate what an employee does or does not do with those particular holidays. Now, if we look at the rights that an individual has, what I've done is I've categorised them into certain areas to make it easier to explain to you. So first and foremost, if we give consideration to wages, your statutory rights here is obviously, we've already discussed, an individual has the right to that statement of particulars that details their main points and their remuneration, for example. They're entitled to receive the national minimum wage from you, at least the national minimum wage. They're entitled to receive an itemised payslip from you, and they're entitled not to have illegal deductions, which is obviously what we spoke about earlier. Under health and safety, and obviously under this element of health and safety, we're keeping it very, it's limited in this particular topic to rest breaks. So they're entitled to daily rest breaks and they're entitled to weekend rest breaks, essentially. There must be an 11-hour gap between one working day and the next under this. And that's the health and safety here. Obviously, health and safety is a law that's so much bigger than that all by itself, but for the purpose of this element of our discussion, that's the health and safety rights there, an individual. Holidays, we've talked about, they're entitled to a minimum of 28 days per year, and that is a full-time equivalent. Obviously, if you get any part-time employees, that's worked on a pro rata basis. They're entitled to receive statutory sick pay. They're entitled not to be harassed by you. Now, that specifically falls under in the event you have an employee that blows the whistle on you. What that is, if you have an individual, say for example, you have bad health and safety practices in your employment, for example, and an individual clipes on you, then they're entitled not to be harassed because they blew the whistle, because they brought those instances to someone's attention. They're entitled not to be discriminated against, and obviously that falls under, we've got sex, we've got race, we've got age, we've got disability, we've got sexual orientation. So you have all these areas that an individual is entitled not to be discriminated against, and they have the entitlement to time off work. Now, time off work, an individual is entitled to unpaid time off work and paid time off work. Paid time off work being maternity leave, paternity leave, adoption leave, time off for antenatal care appointments, for example. Unpaid time off, an example of that would be for trade union duties. If you're a unionised organisation, 16 and 17-year-olds are entitled to time off for training, or to request time off for training. An individual is entitled to receive time off in the event that they're under notice of redundancy. An individual is entitled to ask to change their working hours with you, entitled to request flexible working. An individual is entitled to unpaid time off for dependence leave, so that's really emergency leave in the event childcare commitments, individual child sick, for example, they can phone you at the last minute and request time off under dependence leave. That category alone has obviously a number of rights that an individual is entitled to in the workplace. Lastly, but by no means least, they have the right to make a claim against you in the event you have treated them unfairly. Now, there is qualifying criteria. Predominantly, an individual must be with you for a minimum period of 1 year, but not all instances have what we call protected categories. So not all instances have qualifying periods. And that is, for example, discrimination. An individual may not even work for you, and they can take a claim against you as an employer. That would maybe be going through your recruitment process, as an example. An individual has the right, in the event that you terminate their employment, to receive written reasons for that termination of employment, and they're entitled to receive notice in the event you terminate their employment. And they're entitled to take you to an employment tribunal if you have not followed your own internal procedures, which is the framework we've discussed, which is your contracts of employment and your employee handbook. These two things, obviously a contract of employment is a standard document, and it would be applied to all your individuals within particular levels, and then you've got your senior contracts of employment. Your employee handbook applies to all employees within the workplace, whether they're directors on the executive board or they're your most junior employees. That employee handbook applies to all individuals, and therefore that's about your consistency that you apply across the workplace. Intention behind it is that if everybody knows what's right and what's wrong within the organisation, and you manage those expectations, then predominantly this can be a happy workforce that you all move forward with, and that there are no instances there that potentially you're leaving yourself at risk at. In the event you do get an employee who takes you to an employment tribunal, this documentation, you want it in place so that it protects you and it mitigates your risk. If you have these in place, then you use that as evidence in an employment tribunal, and that strengthens your case in terms of your opinion or your balance of probability at an employment tribunal. The difference within an employment tribunal and your criminal courts is, in an employment tribunal you do not need what's called proof. There is no proof beyond reasonable doubt. It does come down to your word against your employee's word. Therefore, if you've got evidence, i.e. your contracts of employment and your employee handbook, then that is tangible evidence that you can present to a tribunal to say, this is our version of events, and here's the evidence to back up our version of events, and here's the various breaches, or here's the policy that we followed. That's mitigating your risk in the event you end up in an employment tribunal.